was not existing at all. There was no Hindu religion during Vedic period, during Manusmriti period. There was no Hindu religion. Hindu word also was not there. The word Hindu has been coined by Britishers. Remember, see the history. Britishers started recognizing us as Hindus. To begin with, they said Jaintu to us. That was their word. Jaintu means Hindu. They could not pronounce. There was no religion at that time, 2000, 3000 years back. No religion. Not a Muslim religion. Not Christian religion. Not Hindu religion also. Because I said Hindu word was not there. There were castes, that is true, but religion did not exist. Another point as to present law, how it is based on Manusmriti even today. He gave a few examples. I want to add to that. Section 125 of Criminal Procedure Code, in subsection 4, says that wife will not get maintenance if she is living in adultery. That is our law. Right to maintenance is given under Criminal Procedure Code, section 125, to wife, parents, children. But the same section, in subsection 4 says, a wife who is living in adultery, no maintenance. Manu said this 3000 years back. Manu stated as to maintenance. Who is entitled to maintenance? The statement of Manu was, aged parents, infant children, and virtuous wife, they are entitled to maintenance. Every relation is having adjective. Aged parents, they are old. They don't have money to earn. There is no saving. Aged parents, not all. Infant children, till minority, your son, daughter, minority. And virtuous wife, that wife who is loyal to the husband, only is entitled to the maintenance. We have followed that in toto. Moreover, before 1973, this section 125 of Criminal Procedure Code did not provide maintenance to parents. It provided only to wife and children. Manu had provided maintenance to the old parents. This verse I told you, Marathi translation. In 1973, first time, in this new Criminal Procedure Code, maintenance also was provided for parents in addition to wife and children. This is about section 125, Criminal Procedure Code. One more law which you study, Hindu Marriage Act. Everybody studies. Section 5 of Hindu Marriage Act lays down conditions for valid marriage. And clause 5 of section 5 of Hindu Marriage Act says that the parties should not be of superior relationship of each other. Manu said this in shlok number 5, chapter number 3, adhyaya 3. We have taken this from Manusmriti. I cite chapter number which we call adhyaya 3 of Manusmriti. Shlok number same, 5. Our section in Hindu Marriage Act is same, 5. Subsection is also same, 5. We follow this. If there is superior relationship, that marriage will not be valid. Manu said this. Many do not know this. And do you know that this Indian Marriage Act and other Hindu laws were drafted by Dr. Babasaheb Ambedkar himself in 1951, and he presented Hindu Code Bill to the Parliament for passing. And when he drafted the law, this superior relationship was there in the draft. Dr. Babasaheb Ambedkar had taken many provisions of Manusmriti in Hindu Code Bill. This is one example. That is the draft. And when government did not accept this because there was opposition from Hindu religion itself, Dr. Babasaheb Ambedkar resigned. He was the first law minister. After constitution came into force, he was in the government. In 1951, law minister in India was Dr. Babasaheb Ambedkar. And when he was insisting that there should be uniform law to Hindus, and when he drafted that, Parliament could not pass it. He said, no, I will resign. And all these laws, not only Hindu Marriage Act, Succession Act, Adoption and Maintenance Act, all these are Minority and Adoption Act, are based on basic Manusmriti provisions. Dr. Babasaheb Ambedkar had read Manusmriti fully. He had learned Sanskrit. And knowingly he has accepted all these provisions, though he hated some of the provisions in Manusmriti. Now in one verse in Manusmriti, there is one saying